David K. Williams is a magnificent man.
Oh, wow.
If you know him on Facebook, which a lot of us do, he went to North Carolina State, and that's where he got his...
University of North Carolina.
Yeah, one of those. It's wherever the Tar Heels play, because he always talks about the Tar Heels, so my apologies. He got his law degree, and he's been practicing here in Colorado for a long time. He also ran for RTD board, and speaking of parties, he beat both Republicans that were in that race, which is pretty impressive. David also is a candidate for Attorney General, and Corey mentioned that, although we booked him before he announced his run for Attorney General, so I don't think that we're playing favorites. But about a month ago, or at least a month ago, David did this same presentation down in Denver, and it was very well attended. And I think a lot of people are really curious about what their rights are. A lot of us in this room probably know what our rights are, but we're just not sure how to express that. And we're just not sure that there's a lot of other people that agree with us in defending those rights. So my hope in bringing David tonight was to expound upon those rights so that we're all more courageous in expressing those. When you get pulled over by the cops on the side of the road, not tonight, other nights, when the FBI comes to your house and wants to DNA test you because some really bad stuff happened in your neighborhood, any of those situations. So without further ado, Mr. David K. Williams, Jr.
Thank you, Mike. All right. So just a little bit about my background. For those of you that don't know me, I do see a lot of people I know. I was born in Arkadelphia, Arkansas, to parents who were attending a Ouachita Baptist University. This is not the beginning of a Jeff Foxworthy joke. This is true. And my dad graduated and went on to CSU, where he got his PhD. So as a child, I lived in Fort Collins for several years, moved around a lot, and then came back to Colorado in 2002 for good, after spending quite a few years in North Carolina, Chapel Hill and otherwise. Clerk for a federal judge after I graduated from the University of North Carolina Law School. I went 7 straight years. And people that don't know, I say, well, I'm this close to getting my degree after 7 years. So after I got out of law school, I clerked for a federal judge, worked for an insurance company or a law firm that represented insurance companies, torts and insurance law. Great way to get into the courtroom as a young lawyer. Eventually got into some criminal law stuff. I was on the federal appointed list in North Carolina, Eastern and Western District, so I represented people charged with drug crimes, bank robberies, firearms violations, your basic federal crimes. Also did death penalty work while I was in North Carolina, successfully argued before the North Carolina Supreme Court on a death penalty case. It's still good law out there. Didn't get the guy a new trial or anything. It was a procedural point, but it was an important one, and we won. So I'm glad to have done that. Now, before we get into your rights, under the Constitution, your natural rights and all of that, I want to start with what I think is some of my personal favorite poetry. Some of you may be familiar with this. I don't have it memorized yet, but I'm working on it. And if y'all know the last line, some of you will know the last line, please join in with me. This is by noted American poet Jay-Z. The year is 94, and in my trunk is raw. In my rearview mirror is the mother-loving law. I've edited this. I got 2 choices, y'all. Pull over the car or bounce on the double. Put the pedal to the floor. Now, I ain't trying to see no highway chase with Jake. Plus, I got a few dollars. I can fight the case. So I pull over to the side of the road, and I heard, son, do you know why I'm stopping you for? Because I'm young and I'm black and my hat's real low? Do I look like a mind reader, sir? I don't know. Am I under arrest, or should I guess some mo? Well, you was doing 55 and a 54, license and registration, and step out of the car. Are you carrying a firearm on you? I know a lot of you are. I ain't stepping out of spit. All my papers legit. Do you mind if I look around your car a little bit? Well, my glove compartment is locked, so is the trunk in the back, and I know my rights, so you're going to need a warrant for that. Aren't you sharp as a tack? Are you some type of lawyer or something? Or somebody important or something? Now, I ain't past the bar, but I know a little bit. enough that you won't illegally search my stuff. We'll see how smart you are when the canine comes. I got 99 problems. Thank you, Mike. There you go. Referring to the dog, of course. See, that's poetry. That's poetry. Jay-Z does an excellent job of asserting his rights in this story. Now, I will say, no need for the attitude, but he's Jay-Z. So we'll get to more of those specifics. But before we get to some of those specifics about what you can do when you're pulled over, or if there's a roadblock up ahead with DUI checkpoint, or if the federal agents come to your house, I want to talk about some broader, bigger picture issues just as kind of a foundation. So I'm going to ask you guys this, and just yell out the answer, whatever you think about this, because it's kind of a trick question. Do women in Iraq have any rights? No. There's a yes. Yes. You said any rights? Yes. Okay. Do they have all of their rights? More yeses. They do have all of their rights. They are just infringed upon. That is an important concept to understand. We all have natural rights, no matter where we live, no matter what government is telling us what to do. We have natural rights. Now, the question you guys are answering, a lot of you are those rights being infringed? Hell yes. Now, we don't live in one of those countries, but our rights still can be infringed. I want to help get across the message here that you can waive your rights at any time. But if you don't know you have them, you might as well not have them. If you make a conscious decision to waive your rights, good. You've done that. You've waived the consequences of what you're doing. You've waived the situation, and you've waived them. But you do not have to. This is America. You never have to waive your rights. And as far as I'm concerned, the best time to exert your rights is when you've got nothing to hide. When you've done absolutely nothing. That's when they're the most important. Because if you only exercise them when you got something to hide, that just encourages the violation of other people's rights. Because, nobody's going to assert their rights unless they have something to hide. The point is, exert them just for the hell of it. Because you have them. All right, thank you, Joe. All right, a couple more. Coming in a little bit from the 100,000-mile view. Still pretty high, though. Who knows what the Fifth Amendment guarantees a lot of things, but what's one of them? What's probably the most important one? Yep, the right against self-incrimination. Anybody here a Dave Chappelle fan? All right. Anybody know his Take the Fifth skit? All right. Whenever this gets mentioned, I post this on YouTube. He's in front of a congressional hearing, and he's an alleged drug dealer, and he's asked all these questions, and he does all these elaborate takes on taking the fifth. And at one point he says, I'm going to hand you some secret papers, and it just says fifth, F-I-F. I plead the fifth. So remember that. If you haven't seen that sketch, check it out, because it summarizes it. I don't care who's asking you the question. You have the right to remain silent. Hell yes, you do. Absolutely. The question was in front of the IRS. I don't care who they are. You have the right to remain silent. Now, back to my earlier point, does that mean they're not going to violate your rights? Maybe they will. But if you don't assert them, what's the point? Assert your rights, make them violate them if they're going to do so, and then at least you've got an argument to be made later in a courtroom or somewhere else, before an administrative law judge or wherever you might be, or in just a plea negotiation. All right. The Fifth Amendment, quite right. We have a dog running loose in the Miller basement. The part of the Fifth Amendment we're going to talk about here is, I'm going to quote it to you, and it's longer than this, but here's the important part for this discussion. No person shall be compelled in any criminal case to be a witness against himself. That's the language of the amendment. So they can't make you talk. You can say, I refuse to talk, or I plead the Fifth Amendment, the fifth, if that's what you want to do. Now, there was a Supreme Court case, U.S. Supreme Court case that came down in June of last year that dealt with this. And I'm going to read you the facts. I don't want anybody to think I'm misinterpreting the facts. I'm going to read you the facts from the U.S. Supreme Court decision, or at least what I consider to be the most important parts. And I want you to tell me what you think happened. All right, so here are the facts of this case. This is Salinas versus Texas, U.S. Supreme Court case decided June of 2013. On the morning of December 18th, 1992, see how long it took to get there. Yeah, how long it took to get to the Supreme Court. So on that morning, 2 brothers were shot and killed in their Houston home. There were no witnesses to the murders, but a neighbor who heard gunshots saw someone run out of the house and speed away in a dark-colored car. Police recovered 6 shotgun shell casings at the scene. The investigation led police to Petitioner, that's Salinas, who had been a guest at a party the victims hosted the night before they were killed. Police visited Petitioner at his home, where they saw a dark blue car in the driveway. He agreed to hand over his shotgun for ballistics testing and to accompany police to the station for questioning. Now, he's already made some mistakes, but we'll get to those later. Petitioner's interview with the police lasted approximately 1 hour. Now, here we go to the meat of this part. All agreed that the interview was non-custodial. He was not arrested. He was voluntarily talking with the police. And the parties litigated this case on the assumption that he was not read Miranda warnings, because that they weren't needed. Here we go. For most of the interview, Petitioner answered the officer's questions, but when asked whether his shotgun, quote, would match the shells recovered at the scene of the murder, Petitioner declined to answer. Instead, Petitioner, quote, looked down at the floor, shuffled his feet, bit his bottom lip, and clenched his hands in his lap and began to tighten up. After a few moments of silence, the officer asked additional questions, which Petitioner answered. They eventually tried him. They found some other things as well. But they eventually tried him, and the state wanted to use the fact that he refused to answer that question against him. What do you think the U.S. Supreme Court said about using the fact that he refused to answer a question in light of the Fifth Amendment? What did the Supreme Court say? Could the government use that as an implication that he was guilty? I heard a lot of no's. Yeah, they should have said no. Yeah, Wendy's familiar with this. The Supreme Court said, oh, absolutely, we can use that. The state could use that against him. His silence was used against him. Didn't we just read the Fifth Amendment? So how did they come to that conclusion? This is from the Supreme Court decision. Petitioner's Fifth Amendment claim fails because he did not expressly invoke the privilege against self-incrimination in response to the officer's question. It has long been settled, and whenever a judge says it's long been settled, it's probably not, but that's what they're trying to make that point. It has long been settled that the privilege generally is not self-executing, and that a witness who desires its protection must claim it. Although no ritualistic formula is necessary in order to invoke the privilege, a witness does not do so by simply standing mute. So you have the right to remain silent, but by staying silent, you're not executing, you're not exercising your right. This is the U.S. Supreme Court, people.
It's funny how that's not being enforced with testimony in Congress.
That's another issue, but absolutely. Yeah, no, absolutely. It's not a criminal prosecution, but yeah, your point is well made. So, the point of this is you've got rights. But as far as the U.S. government is concerned, or the state government, this is all governments, federal, state, whatever criminal agent you might be dealing with, criminal justice agent you might be dealing with, your rights do not exist unless you affirmatively exercise them. That's just the U.S. Supreme Court. That's just what I'm reading to you. Now, that case dealt with the Fifth Amendment. It's going to be pretty easy to see how they could expand that to the Fourth Amendment, the First Amendment, the Fifth Amendment right to counsel. Oh, yeah, sure, the Constitution says this, but you have to affirmatively assert your rights. So if you don't get anything else from this, remember that. Just because you possess these rights, the government doesn't care. They don't have to care unless you tell them you are asserting those rights. So where does this leave this? And let's say in respect to the Fourth Amendment. Now, the Fourth Amendment Everybody knows the gist of it is you're right. You have the, well, I'll read it to you. You all know it, but the actual language that pertains to this, the right of the people to be secure in their persons, houses, papers, and effect against unreasonable searches and seizures shall not be violated. So what is a good police lawyer going to say if police comes to a house or to a car and wants to search your house? And you don't say, no, I assert my Fourth Amendment rights against unreasonable searches and seizures without a warrant. If you don't say that, here is the argument right here that says they can do whatever they want because you did not affirmatively assert your rights. Now, they haven't dealt with the Fourth Amendment yet, but that's what lawyers do. They take the case from the Fifth Amendment, they argue it in the Fourth, and the Fifth, and the First, or whatever it might be. So just be aware that they've literally said this with the right to remain silent. So use that when you're dealing with any government agent on any official where you're trying to exercise your constitutional rights. So they probably did. They probably did. I have not read that one, so I'm behind in my Supreme Court reading. They deal with all kinds of stuff. All right. Good. That's good. So, when you are in a situation where you do not wish to answer a question from a law enforcement officer or any government agent, remember to say this: I plead the Fifth, F-I-F, like Dave Chappelle. I plead the Fifth. There are so many amendments that I can only choose one. I choose the Fifth. That's David Chappelle. Or quote Jay-Z, but they're funny guys. And you don't have to specifically say I plead the Fifth, but you can say I exercise my right to remain silent. You can say that. Or I choose to remain silent. Say that. Affirmatively say it. So when it comes to the Fourth Amendment and an unreasonable search and seizure, say, I do not consent to the search. I do not consent to the search. Your car, your house, your office, wherever you are, walking down the street, I do not consent to a search. Or you can say, I never consent to a search. Absolutely, get a warrant. Right. Because they can't do anything legally if you assert your Fourth Amendment right without a warrant. If a police officer comes up to me and says, hey, do you mind if I search your car? And I go, sure. What have I done? Exactly. You can find anything at all in there. I can't argue about it because I gave him permission or her. And that's when you exercise it. Marilyn.
Well, Dave, so like all these road, the roadblocks and the checkpoints and all this, can you back it up a step with, am I being detained, where you don't even have to assert, you can just say, am I being detained, am I free to go?
Yeah, absolutely. Yeah, you can.
Without even getting into, I'm declaring.
Well, I assert my rights to remain silent. Yeah, and if every fact situation will be different.
Can't you, am I being,
Oh, absolutely, yeah.
You tell me why you're trying to do this to me.
Yeah, no, absolutely. And we'll get to some more of that. No, but you're absolutely right. So I request a lawyer and am I being detained are also two things to add to your vocabulary. And with the Sixth Amendment, that's in all criminal prosecutions, the accused shall enjoy the right to have the assistance of counsel for his defense. So the right to a lawyer. There's more to it, but for this point, that's what we're talking about. So when you're in an instance where maybe a police officer is continuing to ask you questions and you say, I'm gonna assert my right to remain silent, and I don't consent to any searches. And if they continue to ask you questions, that's when you can ask, Marilyn, am I being detained or am I free to go? So remember that. Because they can ask you questions all day long. And you can say, I refuse to answer the question or I assert my right to remain silent. But if you want to leave at some point, so you say, am I being detained or am I free to go? Those are simple words, but you have to affirmatively assert that. And then at that point, he's got to make a decision, either to arrest you or to let you go. Because they can ask you all day long. They can knock on your door 100 times, and you don't have to let them in. And that's when, especially when you don't have anything to hide, I submit that's when you should do it. And you can also add, about I assert my right to remain silent. I do not consent to any searches. Am I being detained or am I free to go? And I'd like to see a lawyer. Those are affirmative assertions of what you need to do, according to the U.S. Supreme Court. Now, obviously, every fact situation is different, and I am not an expert in DUI law. I know a little bit about it, and I can tell you some about it. But I think some of the things to remember, unlike Jay-Z, always be calm and polite. This is common sense stuff that this room will know anyway. Be calm and polite, but be assertive in your constitutional rights. Carry one around. I left it over in my bag over there, but if you have a constitution, well, have it with you. Have it with your license, proof of insurance, and what's the other registration that you've got to have.
Them's fighting words.
Well, like I said, we can't stop. You can't stop the Iranians from violating their women's rights. All we can do is assert them. We can assert the rights. And into that regard, oh, and I left my phone back there too, but almost every phone has got a recording capability. I encourage everyone to record every interaction with any government agent ever. In Colorado, that's perfectly legal. You do not need permission in Colorado. It is a one-person consent state. So you can record your phone conversations with somebody else without their knowledge. Now, as a social matter, you might be being a jerk, depending on what you're doing, but when it comes to dealing with the state or any state official, you absolutely have the right to record them. You don't have to tell them. My phone, I've got it where it's easy to get on my app, on my phone, and click, record, put it in your pocket. Do it. Because it ends all he said, she said. It ends all, well, he said this, he gave me consent. Well, it's not a video camera, but as my high school football coach used to say, the eye in the sky don't lie. The recorder in the pocket don't either. And so it clears it up. And one thing I've posted about, just quickly back to the Attorney General race, I am in favor of and would encourage the requirement that all law enforcement officers carry video cameras on their person. It protects the cops from bogus allegations of abuse, and it protects citizens from their rights being violated when they've asserted them, because unfortunately, that happens sometimes. Most cops are good, but plenty of opportunities when they've abused their authority. So be calm and cool, remain silent, refuse the searches, and instead of saying, don't ever, just my preference on this, don't ever say, I know my rights. Assert them. Don't say I know my rights. Let him know you do. I am not going to make any comment. I'm not going to consent to any searches. Am I under arrest or am I free to go? Or am I being detained? Am I free to go? And I'd like to speak to my lawyer if I am being detained. Don't get tricked. The U.S. Supreme Court has ruled not an issue. Cops can lie to you. Yep. They can lie to you. They can say, hey, well, so-and-so already rolled on you. We've already got evidence that you've done X, Y, and Z. So why don't you just admit it? Perfectly legitimate, as far as the U.S. Supreme Court is concerned. And any other thing they might think of. Oh, if you don't tell us, such and such is going to happen to you. They can lie. And if you've watched television shows, sometimes there's fictional portrayals of the cops doing just that. But they do it in real life too. So don't get tricked. Refusing a search is not evidence of a crime. And refusing to go through a checkpoint, a DUI checkpoint, has to have a sign that says checkpoint up ahead. Turning around or taking an exit, and they're legally required to give you an opportunity to go off before you get there. That is not evidence of a crime that cannot be used against you. Now, again, does that mean somebody won't stop you because you don't know that? They might. But if they do, go back to step one. Don't say anything. Don't consent to a search. Ask if you're free to go. Yeah, Jerome.
Into a one-way street, or you're allowed to travel around it. The reason I cite this question is in Larimer County now they have a lot of examples where they set up different roadblocks for DUI checkpoints.
Yep.
However, they'll be at a point where there's no other way around them except for a one-way street.
If you go down the wrong way in a one-way street, that's reason for them to stop you. Yeah. So I would don't do that. Don't do that.
That leaves you no option, though.
Wait, correct. But then when you get up to the actual checkpoint, the stopping point, go through everything we've said. If they arrest you or give you a citation for something, now you've got an argument. One of your arguments will be they didn't give me a way to avoid the roadblock, the stop point, the checkpoint. So a lot of this isn't going to stop the police or whatever law enforcement is from abusing your rights, but it preserves your ability to argue about it later. Yes, sir.
Is that opportunity to access a state law?
No, U.S. Supreme Court has ruled that. Yes. Yep. Yep.
So it's like better than the state.
It's better than the state. Yes. John.
Okay, so to add on to that, since you have your recorder going, because in any case in which you're going to interact with law enforcement personnel, you want to have your recorder going, should you then assert that challenge of, do you realize that the sign you posted is just before you have to turn the wrong way down a one-way street?
It wouldn't hurt. You don't even have to tell the police officer that. You can just note it to yourself before you get up there on your recording. Oh, I see a roadblock sign. I'm looking for a way to get off. I don't see one, so I have to approach the roadblock. I mean, and that's a spur of the moment or spontaneous recollection of what's going on. So, yes, sir.
So in a roadblock like that, do you have to show them your ID if they ask for it?
When you get pulled over, you are required to show an ID because when you drive on the streets,
It's a privilege.
I mean, you can call it a privilege, but I mean, the law, the statute says when the state gives you a license, you've agreed to do certain things. And one of them is to hand over your license when you get pulled over. Now, if you're walking down the street, you have zero obligation to turn in to show them an ID. Zero.
Does Terry Frisk allow them to check your ID?
No, a Terry Frisk does not. A Terry Frisk they have to have reasonable suspicion. Now, New York and some places have been playing with this and doing this a lot. They have to have reasonable suspicion that you're involved in a criminal activity. That's not as high as probable cause, but reasonable suspicion. They can momentarily stop you and pat you down and see if you've got any contraband on you. They still have to have reasonable suspicion. Now, and I actually got the exact quote here that defines reasonable suspicion. And lawyers love the word reasonable. That's why lawyers exist. Now, what's reasonable? To different people is different things. It's supposed to be an objective standard, but that's why there are pages of law books all arguing about what's reasonable and what's not. But reasonable suspicion is less than probable cause, and they can momentarily detain you. And this is a quote from a Colorado Supreme Court case, because that can be defined differently in every state. In Colorado, police may detain and require identification if reasonable suspicion of criminal conduct. That's maybe I didn't say that right. They have to have that reasonable suspicion. If they have the reasonable suspicion of criminal conduct, the police may detain and require identification of a person if they have reasonable suspicion based on objective facts that the person is involved in criminal conduct. Now, there's no requirement that you have an ID on you, but they can certainly pat you down and find it. Yes, sir.
Everything you say, I can come up with hard questions.
There's plenty. That's why law students get drilled.
The topic that you just completed talking about, I've got family in New Jersey, and it's quite the deal where if you're walking down the sidewalk after dark, you're going to get questioned, pulled over and questioned by the Gestapo. You just try and not produce an ID and see what happens.
Well, like I said,
I
can't stop them from acting like Gestapo, as you said.
They have to have reason to stop you and interrupt your legal driveway. And they'll say, well, there was just a burglary down the block and the description matches yours, put your hands on the car.
Right.
They can say whatever the hell they want. And
Indeed they can.
On another note of the same ilk, hypothetical situation, I'm driving my Mini Cooper along I-80 heading into Nebraska, out of Colorado with Colorado plates.
Totally.
I pull off to a rest area and I forget to use my turn indicator. All of a sudden I got a highway patrol pulling me over. I want to look in your car. Well, no, thank you.
Exactly.
I don't allow that.
Yep.
Well, you can just wait here till we get the dogs.
That's what they did to Jay-Z.
Well, what's the deal there? I mean, they've got a loop for every one of your loops.
Well, they don't though, because what they're doing is they're pressuring you to give up your rights. Because once you give up your rights, you no longer have an argument in court. Yeah, they can hassle you all day long.
They're doing it a lot on Interstate 80.
Absolutely doing it. They're doing it. None of this is a magic wand to stop cops from abusing their power. It is only a way to keep your rights and preserve an argument when you get to court. If they stop you and say, oh, somebody fitting your description was involved in a robbery a block away, all right, don't consent, make them arrest you, push them to the limit. Now, again, yeah, this is hard. It's hard to do this. But you have the right to do it. And if they arrest you on this, when you get your lawyer, you say, hey, they told me that there was some guy fitting my description down the road. Have them produce that evidence. And if they can't, then that stop is going to be thrown out. So all I can do is tell you how to preserve your rights in court. Nobody can stop an abusive law enforcement agent. I mean, nobody can stop that. You go.
I have a perhaps relevant question. I've been thinking about this for a while. If you do get stopped, and you meet the description of such and such a person they saw a little while ago,
Yep.
There's two possible things. Either they search you, and you may or may not have consented to it,
Right.
or they arrest you because you pushed them that far. Do you have legal standing for an abuse of law case, a civil rights case? If they do arrest you, if you can establish, I don't see anything on your dispatch that shows that there was a robbery down there with someone that looked anything like me.
Did everybody hear that? All right. It goes back to the same question.
The second part of the question will be, and if I'm not arrested and they simply stop me and harass me about it, do I also have legal standing? Because they could say I was not harmed.
All right, a couple things. Technically, yeah, you've got legal standing, but what are your damages? He stopped you for 2 minutes? And that's the type of thing where...
You'll be fired regardless. But
and file complaints with civil authorities. Absolutely, because one complaint, probably nothing's going to happen. But there's been lots of instances where police officers get multiple complaints and somebody notices. So even if it's just you, you might think I'm the only guy that's ever happened to. Probably not. And when you talked about if you assert your rights and I think you said something about it, and you push them far enough, never be rude to a cop. Always be respectful no matter what he's doing. Because if you give him a reason, he will use it. And obviously never touch an officer, no matter what if he's arresting you. Don't resist once he's arresting you. Even if he's got zero reason, don't give him one. Because at that point, all bets are off. So be polite, affirmatively assert your rights, and that preserves your ability to argue about it later. Nothing can stop a bad cop from harassing you, period. I don't care if you're Alan Dershowitz. All right. Now, they're probably not going to do it to Alan Dershowitz because he knows what he's doing. He knows all these rules, and he'll preserve his case for later, either in a criminal court if they file charges or in a civil suit if there have been civil rights violations. So all I can tell you is how to assert them, how to preserve them for later use, and not waive them. Because if they're harassing you and you waive your rights, you're done. Don't be done.
the reason why I asked that particular question is because without some redress, without a civil suit, without a constitutional case, there is no penalty for that officer to stay within the bounds of the law.
Absolutely. So I encourage, my point is, yes, preserve the evidence for the civil suit.
Okay.
Yeah, absolutely.
And you
come talk to me.
Whether or not you were arrested.
Correct.
You can establish through dispatch or...
Absolutely. Now, again, it's a matter of what your damages are. I mean, clearly, if you get beat up for no reason and they break your nose and your leg, your damages are going to be worth a lot more than he wasted 5 minutes of your time. But it's still a violation.
Okay.
All right.
Thank you.
Yes, ma'am.
Concerning showing identification, if I am on a bicycle,
Yep.
my husband and I bike a lot,
Yep.
so we're on the road, not the sidewalk. Are we required to carry and or show identification?
I don't know that. Who are the cyclists in here? I don't know if you're required. I mean, I don't think the DMV doesn't give you a license to ride a bicycle.
I know, but they can take it if you're drunk on a bicycle.
That's right.
Yeah, being drunk is different. Right, no, absolutely. So I just don't know the answer to that. Call me and I can look it up. All right. You can get a DUI for being on a horse, too. I mean, that's happened recently. Yeah. Scott, then I'll come back.
I just wonder about photo radar and photo red lights.
Photo radar, photo red light cameras, those are not criminal charges. They don't even go on your driver's license. That's how they get around. Another constitutional right you have is the right to confront your accuser or any witnesses against you. You have the right to do that. And obviously, if it's a camera that caught you running a red light or one of those automated radar things that caught you driving over the speed limit, there's no witness. So that's why, and they originally tried to use them in criminal cases and even traffic cases. That was defeated. They can't give you a point on your driver's license for any of those camera violations. They call it an administrative fine or administrative sanction. So it's a fine. And the other thing about this is, it's a tax. It works for me. They have to serve you personally with one of those tickets. They'll mail it to you, and most people just fill it out and send it in. You don't have to do that. Now, if they do, sometimes they will go out and pay somebody, a process server, to go serve you with the ticket. If they do that to you, it costs you more because now you're on the hook for the payment of the process server. So it's kind of a gamble. I've done it one time, but the most recent red light ticket I got, I ignored it. They never served me, and I got no problem. But if they do serve you, you're on the hook for the additional cost. It's $80, $100, whatever it is. But just weigh that in your decision.
No.
Unless they.
Hold on. If it's a red light ticket by a camera mounted on a street corner somewhere, right? You do not have to pay that unless they personally serve you with it. The mail is not sufficient.
I've done it 8
Absolutely.
times. No problem. 8 times, no problem.
Don't ride with Jeff. That's the other thing I want you to think.
I see him, I speed up when I go into him.
You see green light stop, he's coming the other
Yeah,
way.
right. Watch out.
David,
Windy.
since you're running for Attorney General,
Yes, I am.
I would like you to clarify whether or not you indeed ran the red light, or if this was just a minor over the sidewalk edge infraction.
I plead the fifth.
Gotcha.
Very good. John.
Since we're on the topic of cameras, do you think that the Metro Police, Denver and otherwise, have managed to calm down about being reported by citizens outside of a criminal investigation?
Well, so the question is, I can't speak for law enforcement on that, about their attitude about being filmed. It is perfectly legal in the state of Colorado to film a law enforcement officer. Now, you cannot obstruct him in any way. You got to get out of the way. You can't mess with his ability to do his job at all. So stay away and you can record. I don't care if they tell you you can't. You can. Again, it goes to preserving a potential case later if they do cite you for something.
How brave you're feeling and whether or not they decide, because I've seen cases, and I mean there was a period around 2010 where I remembered seeing 3 or 4 cases where they would cross a street to assert that you were being involved in a criminal investigation and interfering, and physically molested people, beat them
Again,
for doing so.
Nobody can stop that. All we can do is preserve your case. Yeah. Jeff?
Referring back to our friend's question over here, driving into Nebraska and getting pulled over and having, the police officer threaten to bring the dogs over to, search his car.
Yep.
How long can they detain you in that situation? How does that work?
I wish I had a bright line rule and I could say 47 minutes or something, but it's one of those things where they look at the totality of the circumstances and the facts. Just because you have a Colorado license plate and you're driving into Nebraska is not reasonable suspicion. They have to have more than that. Now, if they have a dog waiting there at the rest stop or wherever, dogs can sniff your car. Dogs can sniff you. There's nothing you can do about that. They don't have to have any type of reasonable suspicion or cause. That's just out there. You're walking in public, and if a dog smells you and hits, you can't stop it just because of that. You can't fight the whatever they find on you if you've got some contraband on you. Now, you might have some arguments about whether or not that dog is sufficiently reliable, so you got to go back and get the records of that dog, because a lot of these dog hits are horrible. They hit everything. All right? So that's what a lawyer will have to fight and get that discovery on that dog, what are his percentages of accurate hits? And that can be litigated. But what's that? Gary Dog Biscuits? Yeah. Yes, Russ.
A dog sensing something represents an improbable cause for search.
Correct. Right. If a dog hits, and assuming the dog is properly trained and meets all those requirements, yeah, that becomes probable cause. Yep, absolutely. And I want to hit this before I forget, then we'll come back over to you. We mentioned briefly the consent to, if you're driving in a car, on any type of motor vehicle in Colorado, you've consented to show your driver's license. You've also consented to take a breathalyzer or a blood test if the police officer has probable cause. So, they have to get over that hump. So it goes back to a case. Let's say they pull you over, and the police officer, you roll down your window, you've got all your stuff ready to hand to them, and just as a practical matter, have it all in an easy-to-reach place, in your visor or someplace easy to get to. Because if you're fumbling through your glove box looking for your stuff, that's probable cause. Or they can make it probable cause. That's one of the things they will say. He was fumbling for his papers. All right? So have it handy so you don't have to fumble through it, and hand it over to him. And if a police officer says, do you know why I stopped you? Go back to Jay-Z. No, sir, I don't. How are you doing this evening? Don't, because he's asking you to incriminate yourself right there. Yeah, I guess I was speeding a little bit. Well, there you go. You just admitted it. Or, yeah, I should have stopped at that red light, or whatever. No, sir, I don't know. How are you doing this evening? Be polite, and don't give them anything to give you a ticket for, or anything else. But if he thinks he smells alcohol on your breath, thinks you're slurring your speech, whatever it might be, that can give him probable cause to have you do roadsides. But if he asks you, would you mind getting out of your car and doing roadsides, what do we say? We say, am I being detained or am I free to go? Because he has to have reasonable suspicion to have you get out of your car and do the roadsides. Now, he can ask you to get out of your car, but if he wants you to do the roadsides, he's detaining you at that point. He has to have probable cause or reasonable suspicion, actually, just reasonable suspicion for you to do that. So at that point, that's when you ask, I'd rather not, your officer, I appreciate your job and what you're doing, but am I being detained or am I free to go? So, because if you do it voluntarily, you've consented. And once you consent, it can be used against you later on in court. But if you say, I don't consent to the roadside, am I free to go? You preserved it for your lawyer to argue it later. Now, whether or not let's say you get cited for a DUI, and let's say you beat the criminal case, the jury finds you weren't driving under the influence, and you're acquitted. If the police officer had probable cause to pull you over, and you refused the roadside, because we've established that he had probable cause to pull you over for whatever reason, you were swerving, but you weren't drunk. So he had probable cause to pull you over and probable cause to believe you were drunk or above the legal limit. Even though you're acquitted, you will still lose your license for 1 year. That is again, back to the administrative side of things. Because you've agreed, when you get your license, part of what you're doing is you're agreeing to submit to that roadside test or the breathalyzer or a blood test, depending on the facts, as a consequence, as a condition of getting your driver's license in Colorado. So you can be acquitted of the crime, refuse the breathalyzer, and still lose your license for a year. Now, you can fight that in an administrative court hearing down at the DMV office, but it's completely different. It's a separate process. Your administrative proceeding, separate process from the criminal proceeding. So just be aware of that. I wanted to make sure you guys knew the distinction there. All right, yes, who's up? Oh, with the mic also.
All right. Two quick questions.
Yes, sir.
I'll steal one too. What's this? Do you know what the statute of limitations is on those photo radars or the red light cameras? Because I may have happened to have one that I didn't answer recently.
I know.
Okay, Jeff. No, he's the Jeff is the expert.
All right, and then my second question follows to Dennis's question, which is like he gets pulled over in Nebraska and he doesn't let him search, and they say, I want to go get the dog.
Right.
You ask him at that point, am I being detained?
Absolutely.
And how long can they say yes?
If they're being detained, they have just said that they've got reasonable
Probable
suspicion.
cause or
right.
reasonable-
And
all right,
then you
gotcha.
can fight that.
All right, gotcha. Now, what's the answer to my other question?
Oh, yeah. Jeff, what's the statute of limitations on those radar tickets or red light tickets?
They have 90 days to serve you. 90 days. You're off the hook. I've got 30 days to go.
Yes, sir. Dennis.
I wanted to broaden this out, but I don't want to jeopardize Mike's tax exempt status. But what would you view as the largest challenges or the most serious issues facing the next Attorney General in Colorado?
Going back. Oh, I can say whatever I want as long as Mike doesn't agree with me. It will be fine. At least officially. Federal overreach. Federal government telling. The question is, what do I think is the major issue addressing the next Attorney General? There's lots of them, but federal overreach is number one. Let's talk about medical marijuana and recreational marijuana for that matter. The feds have no legitimate authority to tell Colorado what they can or cannot do with marijuana. Not if it's grown in this state, harvested in this state, packaged in this state, sold in this state, and consumed in this state. The feds say that, whoa, interstate commerce lets us do this. Well, did you just hear me? There is no interstate involved in this. And the U.S. Supreme Court has upheld this. Even a worse case. In the Depression era or FDR era case, it was a farmer growing wheat for his own use on his own farm. So he didn't sell it, and it didn't cross interstate or cross any state line. Yet the U.S. Supreme Court said, yes, the Interstate Commerce Clause gives us, the feds, authority to regulate what you're doing. Okay? And we're living with that as if that makes sense. Okay? It's absurd. The emperor has no clothes. I don't care if the U.S. Supreme Court says day is night and the moon is the sun. It don't make it so. And for far too long, state attorney generals have played along with this charade that the feds have a legitimate authority to regulate interstate commerce when it's intrastate. And part of what the Attorney General can do is stand up and say the emperor has no clothes instead of kowtowing to the feds when they say jump. And our current administration not only doesn't stand up and say, no, you guys can't do this, they cooperate with the feds. Because, yeah, it's a violation of federal law. So what? We are a state. And U.S. Supreme Court Justice John Roberts, no matter what you think of him in his Obamacare opinion, he said in that opinion, states are sovereign, and sometimes they have to act like it. It's time somebody in the state elected position started to act like it. And I guarantee you, ain't no Republican or Democrat going to do anything but kowtow to the feds. Yes, ma'am.
So, here on federal overreach, that's my favorite thing to hear ever, all the time. Here. So, I'm stuck on what you said at the very beginning, which is that people have rights they can't exercise. How exactly do I have a right that cannot be exercised? If I can't exercise it, I don't have it.
Let me clarify that.
Explain that.
Yeah, absolutely. Let me clarify that. If I said that, that's not what I meant. You have the rights. That doesn't mean someone can't infringe them. That's the difference. You can exercise your right. Someone else can infringe your right.
But then I don't have it.
I disagree. You have it. It's being infringed by someone else.
Why do I have a right but can't exercise it?
Because, yeah, you're born with it. If I've got $10, that doesn't mean somebody can't take it from me. Right? And they have violated my right of self-ownership. There is no magic wand that protects me from being robbed.
You think people should have those rights?
Yeah, right. Well, we're kind of getting into the weeds, and I'll be glad to continue that discussion with you. But I have the right.
That's a big weed.
Oh, and speaking of weed, maybe we need some of that to further this down. But Michelle, I think you and I you can continue this conversation in the corner over there. But having a right has nothing to do with someone else infringing it. I've got the right to life. That somebody can come kill me. I still have the right to live. Someone has infringed that right. I don't have a problem with otherwise the only conclusion is I don't have the right to live because somebody might kill me. That's not, I don't think that follows. Yes, sir.
There's a woman who posts on my blog who lives as a self-described committed anarchist. She paid for her car with silver coin. She consents to nothing in the way of search and seizure. She insists that she has asserted a right to be out there driving without a driver's license. She says that the driver's license, strictly speaking, is intended to regulate commercial vehicles. Is that correct?
Not according to the state statute, it's not. Now, we want to talk about, natural rights and, and whether or not she's got a right when she's born to drive on a public street. I don't have an opinion on that. I'm interested in the practical application of the current statutes as they apply to the federal and the state constitution. I'll sit and talk philosophy anytime, but I don't think that's it.
She has it. It's just being infringed.
It may be. It may be. It may be.
State owns the road. The state has the right to enforce the license.
Which is another issue, because without the state, we wouldn't have roads. That's a joke. Right. Yes. Yes, Michelle.
David, I want to get back to kind of dovetail on what Wendy asked about riding your bike or walking, because we just, a couple weeks ago in Texas had that woman with the earphones jogging who couldn't hear them while they were trying to stop her. I guess she jaywalked.
Yeah.
But apparently the crime was not having, they asked her for ID and she didn't have ID. But is that seriously, are we to that point where we can be asked for our papers in our neighborhood walking our dog? I mean, do we have to carry ID walking, riding our bike?
You don't in Colorado, and I don't know about what the specific Texas statute is, but you don't
in Texas either. But I mean, this was like if you just, why am I being detained? What is obviously if she committed a crime by jaywalking,
right.
That was it. But this whole thing about her not hearing him, what should she have done? You're familiar with the case.
I'm not that familiar with it.
Well, she was running with earphones on.
Just what you're telling me. Yeah, you don't hear the police asking you to stop.
Right.
Or whatever.
And so they tackled her to the ground and injured her.
Hey, Amadou Diallo got shot 42 times for having a keychain. I mean, the cops, there are instances where the cops abuse their power and their authority. And no law enforcement, no governor, no president can stop that.
But you're not aware of any state where you have to just, as a matter of course, out walking,
have an ID.
Papers.
No. Nope.
I actually know the answer to the dog question, though.
All right, let's hear it.
In Jefferson County, at least, your dog is required to have its ID if it's off your personal property.
Yes. That's true in Denver, too. Right.
Yep.
By dog licensing. Yeah. Yeah. So, I find it offensive that I have to ask the government's permission to own a dog or a cat or whatever. No cat? All right. Then I have no problem with the cat law. Right. I don't like cats. That's just personal. No, I have no problem against cats. I know. I did. Yes, sir? Any more over here? All right.
Can you talk a little bit more about property rights? Because I think we've got some big, strong issues along that line, too.
Yeah, absolutely. I mean, specifically like the Masterpiece Bakery case. Yeah, right. The current administration, Republican Attorney General, and his top lieutenant, who's running for the Republican nomination, backed the Civil Rights Commission of Colorado in supporting the couple that wanted to force the Masterpiece Bakery to sell them a cake. The Colorado statute says that the bakery had to do that. Unfortunately for them, in my opinion, that doesn't trump the Constitution of the United States of America, or of Colorado for that matter. So I would not have taken the position of the current AG or his top lieutenant who's running for the Republican nomination. You have a right to free association. And if a state agent can force you to sell to someone, then they can force all of us to buy from someone. Then they can force us to buy from X, Y, and Z. Yeah, well, Obamacare, or they can force you to go buy a cake from that shop. There is no difference between that. And it is offensive to me when the state orders someone to do something that doesn't harm anyone. This wasn't a real issue. That couple could have gotten a cake from anywhere in Colorado or anywhere within the 2-mile radius of that shop. They made this up because they wanted to go to court. They wanted to go to court. And let me be clear on this. I am 100% unequivocally in favor of marriage equality. The government has no legitimate business telling anybody, homosexual or heterosexual, how they can choose to live their life. And as a Southern Baptist, I find it offensive that a religious ceremony between two believers before a man of God or woman in a holy building before God isn't official until the state functionary gives you a piece of paper with a stamp on it for $25. So it goes back to foundational beliefs. Once you get the government involved in something like marriage, they stay involved. And now we've got 1,000 different IRS and Social Security and all these other type of benefits that are tied in with marriage. Well, the state didn't care about marriage until after the Civil War. Historically, like in medieval times, because we have the common law tradition from England, the monarchs didn't care who the serfs married. But they didn't care. It was beneath them. The church would register marriages and write it in the big book and recognize it. John Adams and Abigail Adams wrote great love letters back and forth to each other. You can buy the book. It is awesome. American patriots. They didn't have government permission to get married. George and Martha Washington, no piece of paper from the government. They were married in the church. And the government didn't take an interest in this until they wanted to start enforcing anti-race mixing laws after the Civil War. So then they said, oh, you know what? How are we going to enforce this? You have to come down to the clerk's office. We have to look at you. And if you pass the state's test on whether or not you qualify to get married, then we'll give you a piece of paper. But until then, the state didn't care. And they shouldn't care now. And that's the foundational principle that I believe in. Tony.
I'm going to skip the mic because at least my wife complains that my voice carries. So I'll skip that. What would be the legal designation or difference in between the Masterpiece Bakery saying, we're not going to bake the cake for you, and me hanging a sign on Denny's that says, no homosexuals, I refuse to serve you?
Conceptually, there is no difference to that. But here's the difference. Here's where the progressives get it wrong. They think that bigoted behavior needs state protection because without state protection, it will continue. I guarantee you, without state protection, that Denny's would be out of business in a week.
I would hope so.
Right.
And that baker would too.
Exactly. And the baker. I mean, I know some people the business probably increased because of the publicity, at least for a while. But that type of thing can be addressed without state enforcement. Because the state does not equal society, and that's where progressives and statists of all kinds get it wrong. They say that society should do X, Y, and Z, therefore the government must do X, Y, and Z. No. The government is a subsection of society. And when you and I see something bigoted, and the rest of us see something bigoted, we have the choice not to do business with them. And let me make
responsibility not to do business.
Yeah, absolutely, a personal responsibility. And let me make this point too. We are here where we are, and this is what in 2014. The Civil Rights Act of 1964 is part of the reason we are here where we are. I'm not ever going to debate the pros and cons of what happened 50 years ago. We are here. I'm interested in 2014. And we're not living in 1964 Selma. We're living in 2014 Denver, Colorado, or Colorado in general. And if the progressives really believe in progress, they need to quit looking at 50-year-old statutes and look ahead and how to make the world a better place without the point of a gun. So that's me on that. And about this Baker, all right, the administrative law judge said that, yes, he did violate the state statute, which he did. But like I pointed out, the U.S. Constitution says more and trumps that. Administrative law judge didn't agree with that. So an appeal, I believe the appeal is pending in that case. But that's not a criminal matter. He's not looking at going to jail. But he's been ordered to comply with the statute on an ongoing basis. Now, if he refuses to do it on an ongoing basis, he's in violation of a court order, which one can be held in contempt for doing. If you were held in contempt of violating a court order, you can go to jail. We're not there yet, but I just wanted to clarify that. This was a civil rights case, not there was no criminal sanction whatsoever, although that potential is out there. Yes.
I usually don't need this. Along those lines, I've seen the argument that if you hang a sign, much like you were saying, in your window, we reserve the right to refuse service to anyone for any reason. Does that then make a declaratory statement that basically there is no contract unless the owner of the business enters into one specifically, and thus protect him from court action?
Well, that's what it says, but under court law, it doesn't protect you.
That wouldn't cover it?
No.
Okay.
No. Because it's still a violation of the state statute in this case, and there's federal civil rights statutes as well. You can't exempt yourself from those statutes by doing that. Anything else? Go see Jeff Sheeter. All right. I'll be hanging out. Thank you very much. And that's Williams for Colorado. Williams, the number 4, co.com.